Okay, so now let's go to persons, which is a relatively short topic. So, who is a person? A person is a being capable of rights and obligations and being subject to legal relations. A natural person is a human being. He or she acquires civil personality upon birth. A juridical person naman is a non-human being that is created by law and granted by the latter personality and legal capacity to act. It commences existence from the time it was lawfully formed and extinguished in accordance with law. So, balik tayo sa natural person. Who are natural persons? Tayo, tao. Civil personality shall commence from the time of conception for all purposes favorable to the child and is extinguished by death. Conceived child has presumptive personality. A fetus may be subject to legal relations prior to his or her birth under conditions provided in Article 41 of the New Civil Code, which states that if the fetus had intrauterine life of less than 7 months, meaning premature baby siya, and hindi siya umabot ng 7 months. Pag 7 months, hindi na ito applicable. So, kapag hindi umabot ng 7 months, it has to be born alive and survive. So, dalawang conditions. It has to be born alive and survive for at least 24 hours for it to be considered to have acquired personality. So, para ma-issuehan siya ng birth certificate and death certificate, unfortunately, para ma-consider siyang tao or na nabuhay siya, dapat kung less than 7 months lang yung age ng fetus nung na-expel siya, dapat na panganak siyang buhay, breathing, and nag-survive siya for at least a day. If hindi, then unfortunately, for all intents and purposes of the law, it's not considered a natural person, or he or she is not considered a natural person, or, did not acquire civil personality. If the fetus had an intrauterine life of 7 months, exactly 7 months or more, for as long as it was born alive, or it survived the moment it was separated from the mother's womb, meron na siyang civil personality. So, considered siyang nabuhay. So, ayun, yung pagbabasihan natin is 7 months. So, mako-consider mong natural person siya if, again, kung less than 7 months, dapat nag-survive siya for at least 24 hours after niyang ma-expel sa mother's womb. If naka 7 months naman siya, then as long as alive when na-expel siya sa mother's womb. So, juridical person, examples, the state, okay, the Republic of the Philippines, and all its political subdivisions, other corporations, institutions, and entities for public interest or purpose, created by law, and their personality begins as soon as they have been constituted according to law. So, kung corporations, in accordance with the Revised Corporation Code, for example. Corporations, partnerships, and associations for private interest or purpose to which the law grants a juridical personality, separate and distinct from that of each shareholder, partner, or member. So, sa commercial law, discuss natin yung corporation. Yung corporation may separate personality siya. Okay? Separate yung personality niya sa persons composing the corporation. Juridical persons may acquire and possess property of all kinds, as well as incur obligations and bring civil and criminal actions in conformity with the laws and regulations of their organization. So, just like a natural person, pwede siya maging subject ng contract, subject ng law, ng obligations, pero may certain limitations because there are things that a juridical person cannot do that a natural person can, and at the same time, a juridical person naman can survive as long as hindi siya nadidissolve, while a natural person has a certain lifespan. Capacity to act. So, capacity to act is to act, or pangit kasi mag-define, no, na ginagamit mo lang, inulit mo lang yung words. So, capacity to act. Capacity to, anong other terms natin for act? To act is to conduct, or to, bakit ba ako nagiging anal about this, no? The capacity to do something, okay, ganun na lang, with legal effects, subject to limitations provided by law. It is the power to do acts with legal effect. So, minors, yung mga hindi pa naka 18 years of age, and insane persons, or other similar persons enumerated in law, and those that are adjudged of civil interdiction, are restricted in their capacity to act. So, yung civil interdiction, ito yung accompanying penalty na pwedeng i-impose ng court that would limit someone's ability to act, like to enter into contract or to exercise parental authority, for example, mga ganyan. So, restricted yung capacity to act nila. Wala silang, hindi absence of capacity to act, but may restriction. Like, for example, minors. Minors can't enter into contracts. Okay? Save for some exceptions na meron pa ring legal effect, pero sa oblicon na yan. Or minors cannot marry. Diba? If they do so, it will render the marriage void. Insanity or imbecility, ganun din. Like, for example, insane people cannot validly create a testamentary will, di ba? Or kapag insane, minsan kailangan ng administrator, may ina-appoint na guardian or administrator ng properties niya. Or imbecility, state of being deaf-mute, prodigality, and of course, if na-impose ka ng civil interdiction. Law may modify or limit capacity to act, such as insanity, family relations, imbecility, penalty, age, insolvency, state of being deaf-mute, trusteeship, alienage, prodigality, and absence. So, what do you mean by juridical capacity? It is the fitness to be the subject of legal relations. It is inherent in every natural person and is lost only through death. However, juridical persons, kahit hindi sila totoong tao, like these entities, they have juridical capacity. So, may legal effect pa rin yung actions nila, but limited, of course. Surnames. Legitimate and legitimate children shall principally use the surname of the father. Adopted children shall principally use the surname of the adopter. Illegitimate children shall principally use the surname of the mother, but if recognized by the father, illegitimate children may use the surname of their father. So we will discuss illegitimate children, legitimate and legitimated children, and all other types of children sa family code when we discuss children. The term principally is used, which means that the child may be allowed to use his or her mother's surname or father's surname, as the case may be. The use of the surname of the father is not exclusive, especially there is a fundamental equality of man and woman before the law. So a married woman may use her husband's surname or may continue using her maiden name. If the married woman already started using the husband's name, she has the option to revert to use her maiden name unless limited by special laws for specific purposes, such as in obtaining a passport. If there is a legal separation obtained and a married woman chooses to continue using her husband's surname, she can do so because legal separation does not sever marital relationship between spouses. So a married woman may use her maiden first name and surname and add her husband's surname. Maiden first name and her husband's surname. Maiden first name, yes, and has husband's surname. So ito yung pinaka-common. Like, pangalan mo, for example, Kim, tapos apelido ng asawa mo. Or pwede rin yung may dash, yung Kim Saldo dash surname. And her husband's full name but prefixing a word indicating that she is the wife. So, pangalan talaga ng asawa mo, ng husband, pero may Mrs. lang, MRS dot, before ng first name. Upon annulment, if the wife is the guilty party, she shall resume her maiden name and surname. If she is the innocent spouse, she may, quote-unquote, it's still her choice, continue to employ her former husband's surname unless the court decrees otherwise, or she or her former husband remarries. Upon legal separation, the wife shall continue using the name she uses before such legal separation. Upon death of the husband, okay, may typo lang ako dito, a widow may use the deceased husband's surname as though he were still living, unless she, of course, remarries. Recognition of a father of his illegitimate child cannot compel such child to use the surname of the father. The discretion is with the illegitimate child. Legitimate child shall principally use the surname of the father. Legitimated child, the same. Child conceived before the decree annulling a voidable marriage shall use the surname of the father. Illegitimate child shall use the surname of the mother. If filiation is expressly recognized by the father through the record of birth in the civil register or a handwritten document by the father, the illegitimate child may use the surname of the father. Again, yung operative word natin dito is may. Adopted child shall use the surname of the adopter. So, use of pen or stage names. As a general rule, no person shall use different names and surnames. However, pen names or stage names may be used provided it is done in good faith and there is no injury to third persons. A petition for change of first name may be allowed if the name is ridiculous, tainted with dishonor, or extremely difficult to write or pronounce, or the proposed name is the name that has been habitually or continuously used by the petitioner and he or she has been publicly known by that name in the community, or if the purpose is to avoid confusion. Matters to be recorded in civil register. Acts, events, and judicial decrees concerning the civil status of persons shall be recorded in the civil register. Entries that could be changed or corrected without judicial order. So, no entry in a civil register shall be changed or corrected without a judicial order except for clerical or typographical errors and change of first name or nickname. So, yung mga ganito, actually, i-discuss din to sa remedial law. Yung specific talaga. So, pasadahan lang natin. The day and month and the date of birth or sex of a person where it is patently clear that there was a clerical or typographical error or mistake in the entry, which can be corrected or changed by the concerned city or municipal civil registrar or consul general in accordance with the provisions of the law and its implementing rules and regulations. Clerical or typographical error. It refers to a mistake committed in the performance of clerical work in writing, copying, transcribing, or typing an entry in the civil register that is harmless and innocuous, such as a misspelled name or place of birth, mistake in the entry of date of birth, or the sex of the person, or the like, which is visible to the eyes or obvious to the understanding and can be corrected or changed only by reference to other existing record or records. So, no correction under Republic Act number 9048 must involve the change of nationality, age, or status of the petitioner. So, absence. When does provisional absence take place? A person disappears from his domicile. Yung domicile, yun yung kung saan talaga siya nakatira, na may intention to permanently reside. A person disappears without leaving an agent to administer his property and, of course, his whereabouts are unknown. The judge may appoint a person to represent him in all that may be necessary at the instance of an interested party, relative, or friend. The same rule shall be observed when under similar circumstances the power conferred by the absentee has expired. The appointment referred to having been made, the judge shall take the necessary measures to safeguard the rights and interests of the absentee and shall specify the powers, obligations, and remuneration of his representative, regulating them according to the circumstances by the rules governing guardians. In the appointment of a representative, the spouse present shall be preferred when there is no legal separation. If the absentee left no spouse, any person may be appointed. So, lahat ng to actually nasa rules of court. The judicial declaration of absence shall not take effect until 6 months after its publication in a newspaper of general circulation. The presumption of death under the new civil code is merely one of the evidence which may be invoked in any action or proceeding. Thus, it cannot be the lone subject of an independent action or proceeding. Under the family code, the presumption of death of an absentee needs judicial declaration. For the purpose of contracting the subsequent marriage, under paragraph 1 of Article 41 of the Family Code, the spouse present must institute a summary proceeding as provided in the said code for the declaration of presumptive death of the absentee without prejudice to the effect of reappearance of the absent spouse. So ito, mas madidiscuss natin to pag na-discuss na natin yung family code. Administration shall cease when the absentee appears personally or by means of an agent, and the death of the absentee is proved and his testate or intestate heirs appear, and a third person appears, showing by a proper document that he has acquired the absentee's property by purchase or other title. So what is ordinary absence? Ito yung presumptions. After absence of 7 years, the person is presumed dead for all purposes except for opening of succession. After absence of 10 years or a decade, the person is presumed dead for purposes of opening his succession, except if he disappeared after the age of 75, in which case a period of 5 years is sufficient. After absence of 4 years, the person is presumed dead for purposes of remarriage of the present spouse. So again, 4 years, wala pa rin, yung asawa pa rin nang magpakasal. Pero kailangan pa rin ng declaration of presumptive death. 5 years, pwede nang i-open for succession if yung absentee is at least 75 years of age na. 7 years, presumed dead na. Except for purposes of succession. And after 10 years, pwede nang i-open yung succession as if namatay na talaga siya. Extraordinary or qualified absence. So the following shall be presumed dead under extraordinary or qualified absence after a period of 2 or 4 years. So a person on board a vessel lost during sea voyage or an airplane which is missing. Period is counted from the loss of the vessel or airplane. A person in the armed forces who had taken part in war, or a person in danger of death under other circumstances and his existence has not been known. So, presumed dead na after 4 years if attended by these extraordinary or qualified absence na circumstances. For purposes of remarriage, 2 years naman. So, 4 years, pwede mo lang i-open yung succession. 2 years na may ganitong circumstances, pwede na mag-remarry yung spouse ng absentee. So, who is an absentee? A person that disappears from his domicile and his whereabouts are unknown. And he did not leave an agent to administer his properties. A court may appoint a person to represent the absentee in all necessary matters through a court petition for judicial declaration of absence. When may a person be judicially declared absent? If a period of 2 years lapsed without any news about the absentee, 5 years if an agent was appointed by the former. A period of 2 years since the last receipt of news regarding the absentee, and 5 years if an agent was appointed by the former. If the absentee appears, or without appearing his existence is proved, he shall recover his property in the condition in which it may be found, and the price of any property that may have been alienated, or the property acquired therewith, but he cannot claim either fruits or rents. Okay. So who may file a declaration of absence? The spouse present when there is no legal separation, or heirs instituted in the will, or relatives of the absentee that have interest in succession, or other interested parties with rights upon condition of the death of the absentee, and any competent person appointed by the court. So once the court declares a person absent, such declaration will only take effect 6 months after its publication in a newspaper of general circulation. And the spouse cannot alienate or encumber the absentee spouse's property or the conjugal partnership without judicial authority. Okay, so ano yung presumptive death? So, na-explain natin kanina, diba? Yun yung mga presumptions. But presumptive death arises by operation of law if factual conditions required by law are established. There is no need for judicial declaration of presumptive death unless the spouse of the absentee wants to remarry. Okay, wait lang. I'm just gonna fix that. So for survivorship, if there is doubt as between 2 or more persons who died later will succeed the former, that calls for the application of Article 43 of the new Civil Code. Except for purposes of succession, when 2 persons perish in the same calamity, and it is not shown who died first, and there are no particular circumstances from which it can be inferred, the survivorship is determined according to the following rules. So presumption lang to, rebuttable to by evidence. If both daw under the age of 15, kung sino yung mas matanda, yun yung nag-survive. If naman both are above 60 years old, yung mas bata, yun yung nag-survive. If yung isa under 15 and yung isa over 60, yung under 15 daw yung nag-survive. If both naman between the ages of 15 and 60 pero magkaiba yung sex, yung male daw yung nag-survive. If naman yung both sila between the ages of 15 and 60, tas parehas naman ng sex, parehas babae or parehas lalaki, then yung older yung nag-survive. If yung isa under 15 or over 60 and yung isa between those ages, yung age niya nasa in between 15 and 60, yun daw yung nag-survive. So yung presumptions dito is sa edad, kung ano yung mas stronger. Syempre pag sobrang tanda na, weak na yun. Kapag sobrang bata pa, medyo may disadvantage din, diba? Or kapag in terms of calamity, sino yung most likely magsusurvive? Yung lalaki ba, yung babae? So yung presumption is yung lalaki kasi mas stronger biologically yung lalaki. Parang ganon. So presumptions lang to if talagang hindi mo determine kung sino yung nauna. Kasi importante yung nauna if we discuss succession na kung paano yung successional rights. Okay, so yun lang naman for persons. It's very short. And I think we'll do family code. Maybe marriage. Kaso medyo late na rin and I feel sleepy. Tignan natin. So marriage, tapos another video naman yung property regime. And then, after ng property regime, maybe children, tapos family home, parental authority, support, gano'n. Okay,